Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a couple of things: scientific testimony and admissibility standards, and baby food and autism. I'll have more on that in just a moment. Almost 20 years ago now, in Daubert versus Merrill Dow, the Supreme Court had to decide a little bit more about the admissibility standards for scientific evidence. And essentially what the issue came down to is, when can scientific evidence be admitted when it may not necessarily have the blessing of all of the scientific community? And that can create a bit of a problem for plaintiffs with novel theories of liability, but perhaps it should. There has been a lot of talk recently about science being junk science, not living up to the standards of testing hypotheses and getting peer reviewed and that sort of thing. And when you conduct science solely for litigation purposes, there is at least an element of question about whether you are really doing science or are you really just providing some cover for what is an otherwise unsupported theory of liability. Now, plaintiffs and plaintiffs' counsel never like to believe that their theory of liability and their science is bad, and certainly the same can be said for defense attorneys, and that's why Daubert motions, which is the name of that case, have become such a standard fare in federal and now even in some state courts. The Daubert standard focuses on making the judge the gatekeeper of scientific evidence. Now, you may wonder why someone who went to law school and didn't perhaps get a degree in molecular biology might be the person to decide about whether or not science is reliable or not. And I think that's a fair question, but if the judges actually apply the standards as set by the Supreme Court, it can be a fair and legitimate inquiry. So let's talk a little bit about what the standards are, and I want to also sort of frame it this way. The Daubert ruling was somewhat broad. It said there's a number of factors that you look at, and it laid out those factors. And it said, as well as other factors. Well, now the circuit courts of appeal began adding to all of those factors, and now we have a number of factors that we look at when we're trying to determine whether or not science is good science or not. So this is from the Paoli case in the Third Circuit, and this is what they list as the factors to be considered in a judging reliability of a method of scientific inquiry. 1, whether the method consists of attestable hypotheses, whether the method has been subject to peer review, the known or potential rate of error, the existence and maintenance of standards controlling the technique's operation, whether the method is generally accepted, the relationship of the technique to methods which have been established to be reliable, qualifications of the expert witness testifying based on methodology, and the non-judicial uses to which the method has been put. So essentially what they're looking at there are all these different factors that help us distinguish what is good science from bad science. But while there are all of those factors, the application of those factors can sometimes be problematic. So in that particular case, for example, they talk about fit and reliability. Even if an expert's proposed testimony constitutes scientific knowledge, his or her testimony will be excluded if it is not scientific knowledge for purposes of the case. Helpfulness requires a valid scientific connection to the pertinent inquiry as a precondition to admissibility. For example, in order for animal studies to be admissible to prove causation in humans, there must be good grounds to extrapolate from animals to humans, just as the methodology of the studies must constitute good grounds to reach conclusions about animals themselves. Thus, the requirement of reliability or good grounds extends to each step in an expert's analysis all the way through the step that connects the work of the expert to the particular case. And in terms of helpfulness, they say this. As we explained in Paoli 1, the reliability requirement must not be used as a tool by which the court excludes all questionably reliable evidence. The ultimate touchstone is the helpfulness to the trier of fact with regard to reliability. Helpfulness turns on whether the expert's technique or principle is sufficiently reliable so that it will aid the jury in reaching accurate results. A judge frequently should find an expert's methodology helpful even when the judge thinks the expert's techniques has flaws sufficient to render the conclusions inaccurate. Now, if you read that and listened to that and you are confused, raise your hand. Because, frankly, I'm confused. It looks to me like the court is talking out of both sides of its mouth here. In other words, there's reliability, it has to be reliable, it has to be reliable methodology, it has to be helpful, you don't rely on the conclusions, but if the judge thinks it's bad science, it's still going to get excluded. It doesn't make a lot of sense, and the standards are all over the place in federal court. And eventually, that's all going to have to change. It's going to have to be narrowed down to a set of principles that can be rightly and easily applied. The problem is that science doesn't always fit into a neat or organized basket of goods, and so that can make it difficult. In going through a number of other cases, there are some cases involving the 3 Mile Island nuclear disaster where these Daubert issues came up. And essentially what the court held in that case is there are two major requirements. The expert must be qualified to express an expert opinion. This qualification requirement is liberally interpreted and includes a broad range of knowledge, skills, and training. However, the level of expertise may affect the reliability of the expert's opinion. So, for example, you could very easily have an expert who is just a garage mechanic opine about how a carburetor works, because he works with carburetors every day, and he has the skill necessary to understand the principle of operation, and he makes them work, right? But if his testimony was the carburetor works this way and it produces this amount of pollutant, well, now you're getting a little further away from his area of expertise, and his opinion may not be reliable in that case. But here's also what the court said in that 3 Mile Island case. The grounds for the expert's opinions merely have to be good. They do not have to be perfect. The judge might think that there are good grounds for an expert's conclusion, even if the judge thinks there are better grounds for some alternative conclusion. And even if the judge thinks that a scientist's methodology has some flaws, such that if they had been corrected, the scientist would have reached a different result, it still boils down to the opinion being admissible. So, sort of summing all of that up, here's what the court said. The test of admissibility is not whether a particular scientific opinion has the best foundation, or even whether the opinion is supported by the best methodology or unassailable research. Rather, the test is whether the particular opinion is based on valid reasoning and reliable methodology. The admissibility inquiry that focuses on principles and methodology, not only on conclusions generated by the principles and methodology. The goal is reliability, not certainty. And that is an important statement. Nonetheless, the court continues by saying that the conclusions and methodology are not entirely distinct from one another. The court must examine the expert's conclusions in order to determine whether they could reliably flow from the facts to which the expert and the methodology were used. A court may conclude that there is simply too great a gap between the data and the opinion proffered. However, such an opinion will be excluded not because it is necessarily incorrect, but because it is not sufficiently reliable and therefore too likely to lead the fact finder to an erroneous conclusion. Now, in that 3 Mile Island case, they excluded the opinion of a meteorologist. In the 3 Mile Island case, the plaintiffs wanted a meteorologist to testify about how the plume of radioactive material flew over the area where they were representing plaintiffs. And they hired a meteorologist to do that. And instead of using standard dispersion technology and standard methods of establishing dispersion and the plume, he used unique methods that he helped develop. And here's what the court said about that. Vernier never provided any testimony, documentation, or any other evidence that the numerical models he used are generally accepted within the meteorological or broader scientific community. Although the general acceptance test of Fry was displaced by federal rules of evidence and Daubert, general acceptance in the scientific community can yet have a bearing on the inquiry and be an important factor in ruling particular evidence admissible. A known technique which has been able to attract only minimal support within the community may properly be viewed with skepticism. And here is what the court said at the end of that. Consequently, Vernier's plume movie, as will be discussed, his water model are also lacking in scientific reliability and are inadmissible because of their speculative character. Nevertheless, we believe that the plume movie and water model are more appropriately inadmissible because they lack fit. In any respect, the whole issue for Vernier was that his methodology was not reliable and it did not provide the jury with a piece of evidence that they could use to determine the issues in that case. With that understanding, let's talk about the plaintiff's claims in these baby food cases about the baby food having caused autism. Autism is not a singular disorder. Autism is a spectrum. You have children who are very affected and are unlikely to ever be able to functionally live by themselves and earn a living. And you have others that, with work and with training and with a great deal of therapy, can eventually be taught to live in society and be a functional adult. It is a spectrum. And the problem for the plaintiffs in this case is that while there are certainly some of these chemicals that are associated with harm, for example, let's take the substance of mercury. Y'all have probably heard the aphorism that someone is mad as a hatter. Well, why is it that hatters were mad? Well, the reason is because when somebody blocked a hat, in other words, molded it to a skull sort of thing so that it would fit a particular individual, they used a mercury substance. And mercury leached into their skin, and shall we say it made them just a little bit neurodiverse. And as a result, mad as a hatter came into being because mercury is not kind to a brain. One would assume that it would be tremendously unkind to a developing brain. And for that reason, it might very well be that it could have a causative effect on autism. But the problem is that there has been no study to date which has linked anything to the cause of autism. Here is what the CDC says is all about autism. Autism spectrum disorder is a developmental disability caused by differences in the brain. Some people with ASD have a known difference, such as a genetic condition. Other causes are not yet known. Scientists believe there are multiple causes of ASD that act together to change the most common ways people develop. We still have much to learn about these causes and how they impact people with autism spectrum disorder. Now, that's an important point because the science simply has not developed to the point where anyone can pin down the cause of autism. I've recently seen some theories that suggest that people who took Tylenol during their pregnancy may have exposed their children to developmental disorders that are in the form of autism. Again, those are interesting theories, but none of them have been proved by scientific evidence. And here's what the Mayo Clinic says about the causes of autism spectrum disorder. Autism spectrum disorder has no single known cause. Given the complexity of the disorder and the fact that the symptoms and severity vary, there are probably many causes. Both genetics and environment may play a role. Genetics. Several different genes appear to be involved in autism spectrum disorder. For some children, autism spectrum disorder can be associated with a genetic disorder such as Rett syndrome or Fragile X syndrome. For other children, genetic changes, mutations, may increase the risk of autism spectrum disorder. Still, other genes may affect brain development or the way the brain cells communicate, or they may determine the severity of symptoms. Some genetic mutations seem to be inherited, while others occur spontaneously. Environmental factors. Researchers are currently exploring whether such factors as viral infections, medications, or complications during pregnancy, or air pollutants play a role in triggering autism spectrum disorder. In short, nobody knows what causes autism. There is no science and there is no research that is generally accepted at this point as to what causes autism spectrum disorder. Because the cause has not been sufficiently determined through scientific analysis, I'm afraid that the autism issue in that case is probably simply going to fail. They're going to be unable to meet either the Daubert standard or even the Rule 702 standard for admissibility of expert evidence, because there has to be some reliable scientific evidence that supports an expert's opinion. Somebody just can't go in and say they ate baby food from this company and got, Shazam, they've got autism. I mean, that may in fact be true. You don't know. But it's the issue that you don't know that causes the problem for the admission of that scientific testimony. And without some kind of expert linkage to causation, without somebody testifying that A caused B or B caused C, without somebody doing that, you are never going to be able to get past summary judgment. The judge is going to come in and say, you can't make your case. You can't take this to the jury because you're asking them essentially at that point to speculate on the fact that the baby ate the baby food and got the autism disorder, when in fact there is no way to show that he didn't get, or she did not get the autism spectrum disorder from genetics or some other cause. Now, I suppose it is possible to take a look at the DNA of the child and determine if there are genetic disorders, and if there are not genetic disorders, then you could certainly rule out the genetic disorders, and that would leave environmental factors. But again, nailing down the environmental factors to that particular baby food might be very, very difficult. And also, because the spectrum of the disorder is so broad, it might be very difficult for a jury to, even properly informed, even with great science, be able to come back and say, well, yeah, this definitely caused that. So that's where we are with the baby food case. I thought you might be interested in learning a little bit more about how courts evaluate scientific evidence. I think I may have done a Daubert video earlier, but I didn't have something to tie it to with regard to a current case. And I wanted to just bring this up so that you could take a look at some of these cases and some of the language in these cases. And also, quite frankly, be aware that some of the language in these cases is actually more confusing than it is helpful. It is somewhat funny that the courts who are trying to establish how to get reliable and helpful information to the jury can't get reliable and helpful information to the lawyers trying to get the information to the jury. But our system is a complex and flawed system of justice. No system of justice is perfect except that divined by the Creator. And unfortunately, we're stuck with this system, but it is the best system on earth for finding the truth. I believe that, and I hope you do too. If you have any questions, leave them in the comments down below. Thank you, as always, for watching. When you go out today and you run into somebody, be kind. Speak nicely to them. As I often say, you never know who just got out of jail. So, anyway, thank you so much for watching. We'll catch you next time on here. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.